So our next panel, or our first panel of the day, so we've just finished our 3 keynote speakers. Thank you all for coming and presenting such fabulous insights on Section 1. So we will be starting our first panel of the day on interpreting Section 1, pressing and substantial objectives, democracy, and the judiciary. So I could ask Professor Martha Jackman, Professor Aloke Chatterjee, and Miss Janet Meyer to come up to the front so we can begin. And Professor Peter Oliver from the University of Ottawa will be chairing the panel, and he will start us up or lead us into it. Thank you.
Peter Oliver. Je suis professeur au programme de common law français ici à l'Université d'Ottawa. I'm also the coordinator of our newly formed public law group. I'd like to thank the organizers for inviting me and also to congratulate them on a wonderful conference. The substance of the conference is fantastic, but I'm also impressed by the visual that they've produced here, not to mention the visual of booking a room that has Parliament, the library, and I think probably the people in the back of the room. Justice Stratus, can you see the Supreme Court of Canada? Well, there we go. And I was under the impression that duct tape could hold anything up, and so I don't blame them for the fact that one sign is falling down. So welcome to the panel on interpreting Section 1, l'interprétation de l'article 1er, pressing and substantial objectives, democracy, and the judiciary. I'd first like to introduce our distinguished panelists. Janet Meyer is General Counsel in the Constitutional Law Branch of Ontario's Ministry of the Attorney General. In that capacity, over the past 30 years, she's argued many significant public law cases before all levels of courts. For example, more recently, she appeared in the Chatterjee and Gosselin cases. She is a bencher of the Law Society of Upper Canada and chair of its Equity and Aboriginal Issues Committee. She received the 2003 President's Award for the Women's Law Association of Ontario and is the recipient of the 2010 Ontario Bar Association Tom Marshall Award. Ma chère collègue Martha Jackman est un spécialiste de droit constitutionnel. Elle s'intéresse également aux problèmes juridiques liés à la protection des femmes et des groupes défavorisés. Sa carrière universitaire se poursuit depuis 1988 au programme de common law français à la section de common law ici à l'Université d'Ottawa. Martha Jackman appears regularly before law reform bodies, lawyers, judges, and parliamentary committees. She's acted as legal counsel in a number of important charter cases, including before the Supreme Court of Canada in the Eldridge and Chatterjee cases. In 2001, she was awarded the Augusta Stowgullen Affirmative Action Medal in recognition of her contribution to the advancement of women's equality. In 2007, on lui a décerné la médaille du barreau de Haut-Canada, un honneur attribué chaque année à des juristes ayant grandement contribué à la profession. Finally, Aloke Chatterjee is an associate professor in law at the University of New Brunswick, where he teaches constitutional law and civil procedure. After graduating from Dalhousie University, he attended Harvard University for graduate studies, served as a law clerk for Mr. Justice Ian Binney, and practiced corporate and commercial law. C'est un grand plaisir de vous accueillir à la faculté de droit de l'Université de Montréal. Alors, pour commencer, j'invite Janet Meyer. I believe that speakers are to use roughly 15 minutes each, and I'll be giving you a signal if you go past that. But Janet Meyer.
Thank you very much, and thank you for inviting me to this very interesting conference. I realize that I'm in a minority here as a practitioner, along with all these eminent academics and members of the judiciary. So I thought I would try to make my remarks in that context as a practitioner and as one who works for government. Needless to say, these are my views and not those of the Ontario government. The title is intriguing because it does raise the, I think, vexing question that Martha Jackman and others have put, and David Stratus in particular has been addressing. What is the, how do we achieve legitimacy when we have, in a rights-based democracy? Can we get over the tension of the emphasis on rights and at the same time the emphasis on democracy? I personally think that Canada has come a very long way in doing that. Certainly when the Charter came into being, as Professor Weinrib mentioned, there was considerable concern about what the impact would be. On one hand, we have the judiciary, an independent judiciary, who is traditionally the enforcer of rights, and in the case of Charter, rights of individuals, and of a constitution which is entrenched. At the same time, we have a legislature, and I'm going to kind of interchange legislature and democratic institution, which is elected and therefore accountable. It is a policy maker and certainly attempts to reflect the democratic choice of the community. To my mind, the intersection of the democratic institutions and Section 1 of the Charter are prominent in 3 areas, and I was very glad that Professor Weinrib alerted us to 2 of them that I had wanted to mention. I will therefore sort of shorten considerably. And that is first at the first stage of the game, which is the policy-making stage, where government lawyers give advice to governments on whether or not that legislation is likely to meet a charter requirement, including Section 1. That is a very big impact on the democratic process, and it is one that is present. And for those of you who maybe aren't so familiar with the workings of government, it's not perfect. That probably is not news to anybody. It's an imperfect process. But having said that, there is a very big effort to try and achieve charter compliance without having to go to court to find out if legislation is constitutional. Then we have what I'm going to call the middle stage, which is what happens during a court challenge. I'm going to come back to that. And the final stage, where I think, again, considerable legitimacy is achieved, is in what Professor Hogg has described as the dialogue between the court and the legislature. And as you know, those of you who are familiar with his writings, he and Alison Bushnell did an early article, and then he's updated it. And it identifies the number of times that when that a government has been able to amend and pass legislation after it has been struck down by addressing more particularly the rights issue that the court has identified, so that we don't have in Canada a intrusion, as some would describe it, where the court decides what is constitutional, and that's the end of the game. The democratic process accepts it, but is sort of stuck without being able to achieve its goal. Rather, the goal is informed by the very valuable assistance the court has given in its analysis. And to my mind, that goes a long way to this issue of the balance between the legislature and the courts. What I wanted to comment on, particularly, is the middle ground, and in some ways this may be a bit of a reply to Justice Stratus. The middle ground has been plagued, I would say, by the best, or the approach that the court has taken to the Section 1 test. And yes, we started with Oakes, and we started with what was called a stringent analysis. The question became very quickly, how stringent is stringent, and does the analysis vary depending on the kind of law that's in question? The court has told us that it does. A different approach will be taken to penal laws than will be to legislation which reflects social goals. And to my mind, again, legitimacy there depends very much on the kind of test that the court looks at, the evidence, and I want to emphasize the degree to which these decisions are evidence-based, and finally, the consistency of the court, or lack of consistency, in its approach to the question. So first, moving to the evidentiary issues, as Lorraine mentioned, or Professor Weinberg, I should say, mentioned, in the early days, when we thought of fact-finding courts, we thought of adjudicative facts. We thought of truth-finding. That's what a court was supposed to do. When we move into charter analysis in particular, it is heavily policy-laden, but what is truth there? And I think that courts have struggled with what they're actually finding. Are they finding truth and correctness of a particular policy as it relates to a particular right? To my mind, they really have to grapple with social reality. And social reality is multifaceted, just as policymaking is multifaceted. Is there truth in social reality? And this is really one of the challenges that both courts have and government lawyers have, and those challenging legislation have, in putting forward the appropriate record for the court. I think in the early days there was some thought that the court was, that the legislature was like a court, and that there would be evidence placed before it somehow from social scientists and others, and the legislature would choose and somehow give reasons, and then the court would review it. That's really not how it happens. As you know, legislatures are elected to make political decisions. That's not enough in Section 1, the fact that a government has made a political decision. It has to be rights respecting, and it has to be accountable to the courts in the sense of the fact that there is a connection, that there is an evidentiary basis for the decision. That's where I think the rubber hits the road, though, in terms of difficulties with legitimacy. One of the first cases that I was involved in was McKinney, which was a mandatory retirement case. And without going into a lot of the details there, one of the issues was one of the defenses put forward by the government, which was defending the fact that private employers could choose to require employees to retire at 65. There wasn't a government requirement that you had to do it, but it let the private sector do that. One of the arguments was it has an impact on youth unemployment. And I have to say, I was a literature major, never took economics, had to do a really quick self-education with the assistance actually of a lot of professors of economics. And because the issue was, what is the economic theory that supports what impacts on unemployment? And is there a correctness there? It seemed to us in the end, and I think it seemed to the court, that there's not a correctness. There is a view, there are different views, and when you're looking at empirical evidence for social results, and as Professor Weinberg said, for prospective results, you don't have studies which are going to say this happens for sure one way or the other. What you have are competing and perfectly legitimate, reasonable views of experts. That's the evidence basis that is before the courts. That's in many ways the sources that I think Justice Stratus is referring to. Do we expect our courts to find the correct answer, or do we expect them to assure themselves that the government did not act arbitrarily and did not act irrationally? Those are two different questions. And Professor Sujit Chowdhury, formerly of UT and now I think of NYU or Columbia, I'm not sure, NYU, very helpfully characterized that question as one of who bears the risk of empirical uncertainty. We can't be certain. Therefore, where does the role of the court lie? And when we put forward evidence in constitutional cases, our government, I think, or our office, has done its best, as I know do other offices, whether government or private persons challenging, to make sure that the evidence put forward shows where it lies in the scheme of things. There are huge records before the courts, and I'm sorry, Justice Stratus, if that doesn't happen to be yours as often as you would like, but our experience is that there are mountains of evidence, very often not referred to by the court. Very often saying, well, the evidence doesn't show this, without telling us really why it didn't. And not only is evidence put forward, it's not put forward in a random way. In the early days, there was much talk of a Brandeis brief, and it was expected, I think, by some that they could just sort of select articles from journals or whatever and put them in as though that was evidence. Well, it could have been an article by somebody who was the most prominent expert alive, or it could have been somebody, on the lunatic fringe. How was a court to know? So we have made real efforts to try and have witnesses who are credible witnesses to place the evidence in the spectrum. Thank you. And as a result, as I say, if you look behind many reasons, you will find that there are very large records. The question is, what does the court do with when it gets it? And I'll just finish on this note. I think one of the problems of legitimacy in that area is that the Supreme Court, and not the Ontario Court of Appeal, that the Supreme Court, they heard me say it, didn't they?
I do. Oh.
I'm getting struck down for criticizing the court. There has been some inconsistency in the degree of deference, or whether deference, how deference is given when there is multifaceted and competing evidence which cannot be assessed on a correctness basis. And just to give two examples, in McKinney, an early case, as I mentioned, the court said it would give deference to the legislature when there was competing reasonable evidence. And if the government had a reasonable basis to act, it would accept that evidence. Doesn't mean it would override rights necessarily, but it was required as part of a Section 1 analysis. When we got to Chowuli, a very significant social program, Medicare in Canada, there was again a huge record before the lower courts in Alberta. And when it got to the Supreme Court did not go along with the evidence of the lower courts, or in terms of the findings of what was likely to happen or not likely to happen. It disagreed, and it based its conclusions on the same evidence. And to my mind, it was much more on a kind of correctness standard. It was, this is reality. We've looked at sources, as Justice Stratus would say, elsewhere, and our assessment of those sources is such and such. It would have a huge impact on a very significant social program. And there was no real indication of why evidence was accepted beyond the lower courts. When you turn around and you look at a case like the Hunterian Brethren, there you've got the court back to saying, well, there's competing evidence, there is some social science evidence, and we would give deference when this is a complicated area, we can't expect precision, etc. And in fact refers back to some of the earlier findings as though they shouldn't be interfered with. And I think that's the kind of, with respect, inconsistency that causes not just difficulty for counsel before the courts in knowing what level of evidence and how much to put forward, but also calls into question legitimacy, because the more a court appears to be looking for correctness in the sense that it's the conclusion that you must go to, the more it gives rise to allegations of activism. And I'm not one of those who subscribe to the views of what's called the court party that says the Supreme Court is just another political party. I don't believe that at all. But I do think that because there has been variation in how they approach evidence and the kind of evidence that they have relied on, it does give rise to problems. The other area is judicial notice. Justice Stratis referred to that. In fact, in my experience, it's very unclear when a court will take judicial notice and when it won't. Looking at Gosselin, I think a case in point, the chief was prepared to take judicial notice of things that she described as common sense. And Justice Bastarache, on the other hand, was very critical of the same evidence, saying there was no proof, and the lack of evidence, and saying there was no proof and there needed to be. And I think that, again, that leaves lawyers before the courts with a challenge. If you can bring evidence, don't expect judicial notice. But again, is how much is judicial notice and common sense vary by the judge who's deciding that. So my time is probably up, yes. And I'm sorry that was a rather quick run over, but I do think one needs to remember that evidence-based decision-making involves more questions than just what does the evidence show. Does it show that there are different reasonable bases, or does it show, and should it show, correctness, in particular social prognosis? Thank you.
Thank you, Maître Miner. And we'll now hear from Professor Martha Jackman.
Alors, merci bien aux organisateurs et aux organisatrices de m'avoir invité, et j'aimerais aussi vous féliciter sincèrement pour une conférence vraiment impressionnante. Alors, Janet et moi, on parlait de ça durant la pause. C'est incroyable, je me sens super vieille. Il y a 30 ans de ça exactement ce mois-ci. Le ministre de la Justice, à l'époque, Jean Chrétien, est venu à la faculté de droit prononcer un discours par rapport à la charte qu'il venait de négocier avec ses collègues. Et à la fin de sa présentation, je lui ai posé justement la question, est-ce qu'on devrait être préoccupé par l'article 1 qui semble permettre la justification de violation de droits enchâssés dans la charte? J'avoue que je n'ai aucun souvenir de sa réponse. Soit c'était la réponse d'un politicien, il n'a pas répondu, ou si vous me connaissez, vous allez peut-être soupçonner que j'aimais pas sa réponse. C'est pour ça que je m'en souviens pas. De toute façon, 4 ans plus tard, tel que le juge Sharp l'a bien décrit, le juge en chef Dixon dans l'affaire Oaks a offert une réponse claire et sans équivoque. L'article 1 représente un élément essentiel et très positif de la charte. Dans son jugement, le juge en chef a souligné l'importance particulière de l'article 1 au niveau de la séparation des pouvoirs, le rôle primordial des tribunaux et de la révision judiciaire comme mécanisme d'imputabilité dans une société démocratique constitutionnelle. Alors, le titre en anglais de ma présentation ce matin, Section 1 in Hard Times, Debt and Deficits as a Justification for Rights Violations. Et mon objectif, c'est d'examiner comment l'analyse du juge en chef Dixon dans Oaks s'applique en temps difficiles. Pour ce faire, je vais revoir très brièvement la décision du juge Benny dans l'affaire Nape. Je vais examiner les parallèles au contexte actuel et je vais réfléchir sur ce que la décision dans l'affaire Oaks nous rappelle quant au rôle des tribunaux et les exigences de l'article 1 en matière de considération financière ou budgétaire en temps difficile. Alors, comme vous le savez sûrement, dans sa décision dans l'affaire Terre-Neuve, Conseil du Trésor et Nape en 2004, le juge Benny a reconnu une violation de l'article 15 et devait donc examiner la justification proposée par le gouvernement de la Terre-Neuve quant à l'abrogation d'un paiement en équité salariale que la province avait permis et qui violait les droits à l'égalité des bénéficiaires de ce paiement. Le gouvernement de la Terre-Neuve a plaidé que le déficit en Terre-Neuve à l'époque avait augmenté au point de compromettre la cote de crédit de la province sur les marchés financiers internationaux. On faisait face à un déficit anticipé en 1991-92 de plus de 200 000 millions de dollars. Et le juge Benny a accepté qu'il y avait un objectif urgent et réel, qu'il y avait un lien rationnel entre le report du paiement d'équité salariale et la possibilité d'éviter une crise financière grave. Pour lui, c'était une atteinte minimale. Les réductions dans d'autres secteurs de l'économie auraient pu engendrer encore plus de bouleversements sociaux et l'effet préjudiciable pour les bénéficiaires l'emportait sur l'importance de préserver la santé financière d'un gouvernement aux prises avec une crise financière grave. So, what are the parallels between the situation Justice Binney examined in NAPE in 91-92 and the current fiscal situation? Well, January 6, 2012 report by TD Economics indicated that the current fiscal deficit in Newfoundland is actually $295 million, and these are 2010 figures, the latest available. The federal deficit is $56 billion, and the Ontario deficit is $19 billion. So according to the logic of Justice Binney in the NAPE case, as my colleague Vince Calder had pointed out at the time, the fiscal emergency on the scale of what existed in Newfoundland at the time would have justified suspending the application of the charter, not only in Newfoundland, the year before, the year after, and for a number of years, also in British Columbia, Alberta, Saskatchewan, Ontario, and Quebec in 91-92. But what about the current logic of NAPE? Essentially, Justice Binney's reasoning would justify the suspension of charter rights, not only at the federal level today, but also in Ontario. Or to be more precise, would justify the suspension of charter guarantees that create any kind of significant fiscal burden on the public treasury. So long as, like in NAPE, the government's objective in limiting rights is to protect the government's credit rating, to maintain investor confidence, to safeguard the government's ability to manage debt. Section 1, justification for violating individual rights. Now, who would be so fiscally irresponsible or naive as to argue that debt and deficits are irrelevant at the Section 1 stage of analysis? What? No. In the pre-NAPE world, where cost was at least in principle not a relevant factor under Section 1, courts simply refused to find Section 7 or Section 15 violations in virtually every case involving poor people's charter-related social rights claims. So the relevant question isn't whether financial or cost considerations should factor into the Section 1 analysis, but rather how should they factor in? So what evidence did Justice Binney rely on in NAPE? Justice Binney summarized the evidence put forward by the provincial government as follows. The only evidence consisted of an extract from Hansard and some budget documents. Justice Binney went on to caution, however, and here I'm quoting, "There are serious limits to how far the courts can penetrate cabinet privilege in order to require information about the deliberations of the Executive Council. What transpires in the budgetary process, of course, lies at the high end of cabinet confidences, and here there was no need to precipitate a confrontation between the courts and the government. In my view, the material brought to the board's attention, and of which we may take judicial notice, is sufficient for the purposes of disposing of this appeal." And Justice Binney concluded, and again I quote, "The severity of the measures adopted, including the cut to pay equity, corroborates the government's statement that it believed itself to be in the middle of a fiscal crisis." I have spoken in the past about presumptions of innocence and guilt that apply in the Charter social welfare context. In particular, the presumption widely applied by judges that the Charter should not prevent governments from making the choices they see fit in the face of competing demands for scarce public funds, and the presumption that those who question those government choices are suspect and should be subject to the heaviest burden of proof. Nape illustrates how these attitudes play out in a context of fiscal crisis. In particular, Justice Binney's approach to the evidence reflects prevailing presumptions that governments are innocent in the decisions they make around the management of deficits and debt, and that the Charter has virtually nothing to say to those who question government spending choices, irrespective of the disproportionately adverse effect these choices may have on disadvantaged groups. A recent federal Department of Finance document entitled Making Choices, the Budget Process, provides useful insight in this regard. And here again, I'm quoting from the document. The report explains that fundamentally the budget is defined by choices. The shopping list of demands for new spending, tax cuts, and debt reduction is always greater than the money available. Trade-offs must be made. In the build-up to next month's federal budget, the talk is once again of debt, deficit, fiscal crisis, and restraint. Trade-offs are being made. The only question is, which ones? Finance Minister Flaherty's critics have pointed out that the cost of federal tax cuts he has made since his first budget in 2006 will exceed $220 billion by 2013. The decline in business tax revenue alone during that period is $58 billion. A World Bank PricewaterhouseCoopers report recently ranked Canada lowest in corporate tax rates of all G8 countries, lower even than the United States. In terms of individual taxation, taxing capital gains at half the rate of employment income has created a $3 billion loss in revenue in 2008 alone, and half the value of that $3 billion tax loss went to the richest 1% of Canadian tax filers. So what does all of this have to do with the 30th anniversary of the Oakes decision? In Oakes, Chief Justice Dixon affirmed, and I quote, "It may become necessary to limit rights and freedoms in circumstances where their exercise would be inimical to the realization of collective goals of fundamental importance." Chief Justice Dixon cautioned, however, that where evidence is required in order to prove the constituent elements of a Section 1 inquiry, it should be cogent and persuasive and make clear to the court the consequences of imposing or not imposing the limit. A court will also need to know what alternative measures for implementing the objective were available to the legislatures when they made their decisions. There is little evidence of the collective goals of fundamental importance that have been achieved through $220 billion in tax cuts to the wealthiest Canadians and corporations over the past 6 years. Much less the benefits of that cut to the 3.5 million adults and children currently living in poverty in Ottawa and elsewhere in Canada. Conversely, there is mounting evidence of the very high cost of government failure to address poverty, homelessness, and other determinants of health. The Oakes test imposes a stringent burden of proof on governments to defend rights violations. It is systemically discriminatory to alter the evidentiary and other requirements of the Oakes test in cases of rights violations that result from government choices around how to manage deficits and debt. In the current fiscal climate, it is imperative that judges fulfill their constitutionally mandated role of providing a rights-based accountability framework for executive and legislative decision-making that ignores or undermines the rights of marginalized groups. If there is one area in which rigorous, evidence-based judicial review is essential, it is in relation to hard times as a justification for charter rights violations. Merci bien.
very much, Professor Jackman. Now hear from Professor Aloke Chatterjee.
Okay, great. At the outset, let me warn you, I might say a few outrageous things. I'm on a bit of pain medication in my experience. That either means that you say things that perhaps you shouldn't, or you say things that you mean, but you say it in an impatient and harsh way. So with those caveats in mind, my remarks today will reflect on Section 1 and disability rights. In the brief time that I have, I'd like to do 4 things, if that would be possible. One, I'd like to present a case for why we should look at Section 1 through the lens of disability, and the disability cases in particular. And as part of that, I want to talk a little bit about how I think we should approach this sort of analysis. The second thing I want to do is identify some of the conceptual difficulties with the Section 1 framework that flows from an examination of these cases. And then I'd like to talk a little bit about costs, which Martha has already spoken a bit about. And then I want to end by asking the very basic but important question: why should anyone care about these conceptual problems that I've identified? Am I just doing it for, without any particular utility? And I would like to talk about those things. And just in case anyone's wondering, I've asked Martha to tap me to let me know how my time is progressing. So it's not that she's like objecting to what I'm saying. At least I hope not. At least that's what I'm going to think. So first of all, let me say a little bit about why I think we should look at the disability cases. I think that I came to constitutional law with the background in human rights and disability advocacy, and I also, early on in my legal studies, I read a piece by Judith Mossoff at UBC, and she did an empirical study of human rights cases alleging discrimination based on disability, and she pointed out some anomalies that took place. And ever since then I realized that you can tell quite a bit about legal doctrine by looking at these anomalies, and I also realized that these anomalies were understudied. And so hence I think that you can learn something from with Section 1 by looking at these cases. But the real question is, how do you study these alleged anomalies? And I've been on sabbatical for the last few months, and I've taken the time to read more fully some writers that I haven't read in a while, and in particular I've been quite taken up with the work of Professor Jacob Tenbrook, who was an American academic. He was a lawyer, but he ended up teaching outside of a law school, and he was the author of perhaps one of the most cited or most influential articles, The Disabled in the Law of Tort. And I find myself drawn to his methodology because, one, it seems so prescient, since it happened well before the 80s and progressive jurisprudence. And I like it because it also takes legal principles and legal rules very seriously, and thinks that there's something that, if you're interested in social justice, you have to pay attention to these things. And I'm not going to discuss his work because tort law is not our focus, but I do think from reading his work over the last few months, I think there are 4 important insights that come out of his corpus of work, and I'll just outline them because I think they have implications for my analysis on Section 1. The first thing that he observes is you have to focus on where the law, in this case Section 1, interacts with the lived experiences of persons with disabilities. The second thing he says, you have to look at these sites, you have to look at both the legal principles that's the test doctrines, balancing standards rules, but also the manner of application at these sites. And I think that's particularly important when we talk about Section 1. It's very easy and formulaic to repeat the three-part test, but I think when you look at the effects and the manner of application, I think tells us quite a bit. The third thing that he did is that he developed this concept of integrationism. And I don't need to develop it too much further. I'll just say a few words when I need to at the appropriate time. And finally, he was skeptical about the role of judges to develop the law. In this case, he was talking about the common law in a manner that was compatible with integrationism. And I think that those four teachings that come out of his work, I think, influence the way I look at the Charter in Section 1 in the disability cases. Now, in a limited amount of time, it's simply not possible to go through every case, and that would be rather boring. So instead, I'm just going to give you the flavor. And earlier, Professor Weinberg spoke about some institutional incoherence in Section 1. I would put it to you that incoherence in Section 1, at least when it comes to the disability cases, was evident from the very outset, and indeed some academic lawyers commented on it, and that this incoherence has only intensifies, or at least hasn't been resolved in any kind of meaningful way. So what is this fundamental incoherence? Well, the first Section 15 equality case was, of course, Eaton and Brant County Board of Education, which dealt with an attempt to get an inclusive placement for a pupil in an Ontario public school. And it was an unsuccessful claim. The next major disability case was Eldridge, which Martha was involved in. And there it was a successful case, right? But I think when you compare the two, you see that fundamentally there was some disagreement about the relationship between reasonable limits in Section 1 and reasonable accommodation in the human rights context. So in Eaton, the failure to provide reasonable accommodation amounted to discrimination, whereas in Eldridge, it appeared at least that Section 1 reasonable limits were at least part of the same family. Okay, and although the Supreme Court has said that you have to keep the different analytic frameworks between Section 1 and human rights separate, I think by looking at them more holistically, I think you get a better sense of the dynamics at play. And I think that this problem of reasonable limits and reasonable accommodation in the disability context has never really adequately been resolved. So that's one of the problems. And the second problem is, of course, the issue of cost. The Section 1 machinery, the three-part test. I put it to you that it's only good at the easy cases. Eldridge was an easy case because the expenditure involved was quite small. I believe it was in the range of $100,000 or so. It wasn't a large part of the health budget. But in terms of Section 1 machinery, it doesn't tell you how to deal with the more difficult cases, accepting, as we now must, that financial realities play a part. How do we know when a financial expenditure is too costly? How to draw the line, or even how to attempt to go about drawing the line, it seems to me, especially in disability cases, has proven very difficult and nearly impossible to predict. But I think when you look at the Section 1, and you can, especially when you look at it in general compared to other human rights cases, at least in the disability cases, focusing on cost, I think, doesn't give you a complete picture of the dynamics. So while the Supreme Court is very concerned about costs in some contexts, in other areas, for example, in the context of driving, and in the human rights case called Grismer, the Supreme Court mandated individualized testing of drivers to see if they could drive safely, if they had a visual impairment, which is a costly program. And So sometimes cost is not a big deal, and sometimes it is a big deal. And I put it to you that it's cold comfort for those of us who are interested in disability rights, and I say this as someone who can't see. So you're hard pressed to get materials or library books in alternative formats, but if you happen to have a visual impairment that perhaps might let you drive, then the state should fund individual assessment to permit driving. When the reality is, if you want to improve the social conditions of people who are blind or visually impaired, for the majority of the people, giving them access to driving, to the institution of driving, is simply not helpful and doesn't really address their social situation. So I put it to you that the formal machinery of the three parts Oakes test is certainly incomplete, and the issue of cost is also sometimes it's more relevant than others, and it's very difficult to say when that is going on. So what does Professor Tenbrook's teachings have to tell us about how we might re-envision the Section 1 machinery? Here, I think that first of all, we have to actually develop a more context-sensitive way of determining limitations on rights. And so part of my concern is that Section 1, I put it to you, is both not refined enough to do the heavy lifting, but also in some respects is also too transparent. I don't think, sometimes Section 1 does require judges and advocates to be explicit in their views, but the reality is no one wants to be put in the position of having to order, sorry, your disability just costs too much, right? And so having to avoid having to do that in the Section 1 machinery in unrefined ways, I think has a centrifugal effect and pushes and creates incentives not to reach Section 1. And you see that most prominently, I think, in the Ottawa decision, where I think it would be very difficult to do the Section 1 analysis, since the only treatment that was available for the plaintiffs in the case was the treatment they were seeking, and there was simply nothing else. So I think that from that point of view, this centrifugal effect on other charter rights, I think that can at least in part be attributed to a deficiency in the Section 1 machinery. Let me say a little bit about the next parts, about the difficulty of viewing this Professor Tenbrook's statement about being, slightly tongue-twisted, the difficulty of assessing legal norms from an able-bodied frame of reference. Here, I think, particularly in the cost context, right? I think the baseline problem, the incremental cost of providing an accommodation that's after the fact is obviously going to be higher than if the institution is made to be inclusive from the very beginning. And I think at what stage, when you say too much, is you have to draw a line at not only how much cost is too much, but also what is the true cost. And I think that here, Professor Tenbrook's principles of integrationism, I think, would say something about how we actually have to calculate the real cost. It's not the cost of, the complete cost of the do-over shouldn't be the cost consideration that's subjected in the Section 1 analysis. It seems to me it has to be discounted by an appropriate factor. But exactly how to do all of this within the Section 1 machinery still remains unclear. Finally, who cares? I think that's, and I have these conversations with other people who are interested in disability rights, and you know, people say, oh well, the law is just hopeless. You know, why bother? Like we should be directing our attention at you know, speaking to other policymakers. Not that I think that shouldn't be done. I just think that you shouldn't completely neglect the law. But I also think that we have to be worried when the law itself inculcates discriminatory positions, right? When the discrimination actually becomes embedded in the law itself. And I think that's where Professor Tenbrook's work is most interesting to me from that point of view, because Section 1 has implications beyond the instant case. So if we think of, you know, the obligation to develop the common law in a manner consistent with charter values, and we have Section 1, you know, exerting this centrifugal of force, this effect, this sort of dark matter effect on the rest of the Constitution that's hindering its development, it's, you know, it's not, you know, it sort of impairs evolution of the right, and also complicates how one, you know, evolves the law in a charter compliant, or at least charter inclusive manner. And secondly, of course, even if you pass a Section 1 threshold, given the connection between the manner in which Section 1 is violated and constitutional remedies, I think that also has an implication. And the tying of the remedial regime to the Section 1 structure, particularly in the early cases, I think that also has implications. And if you're interested in advocacy, the remedy actually, you know, it matters a great deal. So all of this leads me to be, somewhat cautious in thinking of Section 1 and whether it's such a robust safeguard, at least through the disability lens. But I think the fact that Section 1 originally had such promise, and I think there are these jurisprudential tools that can think of how we might reorient it. I think that, you know, I don't think it's a futile effort, but I think that one simply can't be naive and be completely euphoric and celebratorial. Thank you.
Thank you, Professor Chatterjee. We've got, I think, about 10 to 15 minutes for questions, so you saw what happened before. Someone will come with a microphone, and perhaps you could identify yourself and also say whether you'd like a particular panelist to reply or if you'd like comment from all of us.
Does anyone have any questions?
Thanks to all the panelists. I think it was a fantastic dialogue with the earlier panelists in terms of the earlier speakers in terms of the challenges of Section 1. You know, when the rubber does hit the road. I'd like to maybe get a bit further discussion about this notion of cost and how the government responds or tries to integrate arguments of cost in its own materials and the limits that it faces when trying to make those arguments, perhaps drawing on what Professor Jackman was pointing to, and also Professor Chatterjee, that you have this argument of cost implications that is advanced as a justification for certain rights infringements. But there's also limitations in terms of what the government feels it's at liberty to offer in terms of the internal discussion. So I wondered whether from the government lawyer's perspective, if not the government's perspective, you could speak to a little bit about some of the challenges you face in terms of trying to put together a record and justifying these kinds of balances between where cost considerations are at play, and perhaps the other panelists then could engage with you on that.
Is this on? No. sorry, I'm technically challenged. First, I have to say, in my recollection, I'm not aware of Ontario ever putting forward cost as a primary defense to date. However, certainly the cost of some programs has been put forward for context at the very least. And I'm thinking of one case where we at least wanted to indicate to the court how much an increased, a requirement for increased spending would be. And it's, we had the information, we put it forward from the Minister of Finance. I do remember the first time though I met the ADM there and I went over and I said, can you just show me the budget please? And he said, Janet, it's locked in a safe place way out of Toronto. I said, oh, okay. Well, there was a request for it, certain budget documents, and there was a request for production actually, which we resisted. However, I think the bottom line there was we were not really relying on it as being the sort of the significant defense to the challenge. It was more context, and there was a real question as to ultimately how relevant it was. You know, NAPE was front and center finance, but others have been more restrained. Who knows what will happen in the future with these circumstances? I'm not sure if were you asking more about how you would how we put forward evidence? Generally affidavits, generally with...
I guess what I'm interested in, I've been told I should identify myself. I'm Professor Vince Kesmersky. I teach at Carleton's Department of Law and Legal Studies. What I'm interested in is the kind of tension, right, that the government will face and that the litigants on the other side have to kind of deal with, where if budgetary constraints are an issue, there's going to always be this kind of tendency for the government to say, well, we can give you a certain amount of information about this, but the rest of it is locked up in cabinet confidence, for instance. And you know that played out in NAPE. And it's a very difficult thing for parties on the other side to be able to then come back, right? And so it goes a little bit to what Justice Stratis was talking about in terms of the record before the court, right?
Yes.
And the thing about Section 1 cases is that you're not dealing with private litigants. The government is on the other side with all of its resources, with all of its policy experts, who it should be able to put into the record before the court. And then it makes choices about where it's going to limit access to certain information. And so I wonder about that tension in terms of how, as someone who's on that government side, I recognize you can't speak for them, but how do you feel that plays on your role in terms of your ability to kind of advance those types of arguments, whether it's for context or as the main argument?
Yeah, well, part of it is what you're advancing. I mean, context, we have budgets, we can show what portion of the pie health spending is, what portion of the pie education spending is, etc. I mean, one can conclude that one can always tax more if that's what has to happen, or you can reduce spending. But, you know, again, speaking for myself and for the cases I'm familiar with, we have not argued that, you know, this cannot happen without taking a particular other kind of program away. That choice has not been suggested as relevant, as something that the court should really address. I think there's a tension in going into particular government's economic theory, and that varies. And in that way, one does it usually through independent witnesses. So that goes back to my comment about economists. And I have to say, one of my early sort of learnings was that scratch economic theory too far and you get into political theory. So, you know, again, what is the truth of economic theory? I mean, numbers are numbers, and certainly one does one's best to show what is there that can be assessed. But I'm not answering your question very well, but that's because we really haven't been doing it, I don't think. And, you know, I think Martha's paper contemplates that it's going to be happening more, and that there will be these tensions arising, but I don't think I can be more helpful than that.
I think it's a great question, and it goes to your earlier question. And is the government engaged in evidence-based cost saving? No way. No way. This is ideologically driven, just like other areas of government policy. I mean, we're in a democracy at some level. We get what we vote for. But I think a really great example of that is Aloke, which Janet's really familiar with too. As Aloke pointed out, you know, why does that stand out as the rare winner? Well, for two reasons. One, $150,000 was what the trial judge found that the rights violation would cost to remedy, which was 0.002 of the provincial healthcare budget. That was the evidence accepted at trial. And so that was one part. It was really cheap to grant the equality rights claim in that case. But there was another really important subtext in that case, I think, which was certainly in our claim, we alleged that the government actually had no clue how much money it was really saving. And we asked, how much are you saving, you know, when you refuse to spend $150,000? And decision-making within that vast, complex healthcare system is not evidence-based, and they had no clue, and they were not able to answer. And so our claim is that, in fact, this was false economy. They were spending way more than they were saving by refusing to provide interpretation services because people were going back over and over and were getting sicker and sicker. And I think this is the point that I'm trying to make in my current paper, is that this notion that we have no money is false. It's an ideological choice, what we tax, what we don't, who pays, who doesn't. And increasingly the evidence, at least in the international human rights sphere, and a lot of it is coming in the area of determinants of health, some of it being done here in Canada, is that we are blowing so much money by not making modest investments in these areas. So the idea that this is too expensive is actually, it's false economy. And that, I think, here I would, you know, say to Justice Stratus, there is one thing that judges are supposed to be good, that lawyers are supposed to be good at, which is weighing evidence. So do your job. Make them give you the evidence, and then look at it critically rather than with the same ideological gloss that we're getting from the finance minister. We deserve more than that in charter review.
How does this work?
It's working.
Oh, okay, great. I think Vincent's question is really telling, particularly in the disability front. There was recently a case in New Brunswick. I'm not sure what its style of cause is, because I think maybe one of those cases where the individual in question is referred to by initials. I had some connection with the case because I was on the Human Rights Commission in the very early stages, but I was off the commission by the time it went to judicial review and made its way to the Court of Appeal. In that case, the issue concerned the manner in which the Department of Social Development in the province was funding home care for certain individuals that it was contended couldn't be accommodated in the social services system in New Brunswick, and in fact were being sent across the border to Maine. And there, I think that at least when one reads the decision of the Court of Appeal, and I encourage you all to read it, where not only the human rights claim was advanced, but also a charter claim as well. And in response, it seemed that there was some computation of how many millions of dollars it was the province was spending on a per individual basis, and basically that one way of reading it could be, well, we've thrown so much money at it, what more could we possibly do, right? In this particular case, the family wanted a placement within the province, and because they couldn't visit their child outside of the country, and it was a very, very sad case. But you sort of realize that the litigants are and the commission was at a very difficult position in scrutinizing the financial picture. It was only when the provincial ombudsman, Bernard Richard, did a study in which he questioned the rationale and thought that maybe maybe services could be provided internally to the province in a more cost-effective manner, or in a different manner that you got a picture. And he was able to get further because he was the provincial ombudsperson. And you sort of realize that it's also a defense of why we can't do it, it's too expensive. But then even when government does something, sometimes the amount of money can also be used in a way, well, it can't be discrimination. We've spent all this money. But when the question is really, is the money being spent in a non-discriminatory manner, or even an appropriate manner? I think that we run into difficulties. So I think the question of money can be telling, both, from both sides of the coin.
Okay. I think we have time for one more quick question.
My name is Prabjot, and I'm a third-year law student at the University of Ottawa. And my question is directed towards Professor Chatterjee. Towards the end of your presentation, you mentioned that we have to be worried when discrimination becomes embedded in the law itself, and that there's jurisprudential tools to reorient that. And so I just wanted to have a little bit of an idea of what tools are you referring to specifically, as I can't speak for everyone, but I mean, I know myself and some of my peers, the reason for coming to law school was to use the law as a tool to help persons with disabilities and disadvantaged groups. So what are some of the tools that you are referring to in terms of how we can reorient the law to ensure that it's not actually discriminating and actually doing what it should be in order to help people?
That's a huge question, and I'm not sure I'll be able to address it in the short time we have, but I think one thing that occurs to me sometimes, well, the tools in particular were the analytical tools of Jacob Tenbrook and how he brought together a social movement in the United States, and he was quite successful at adopting a number of legislative changes. So you can learn a lot from history. But I also think just in terms of why lawyers that are interested in doing this public interest kind of work, I think you have to pay attention to the law and use the tools. And I think lawyers have important skills, and I think part of it is also assisting in finding the right kinds of cases to litigate particular cases. Martha mentioned, why Eldridge was one of the rare victories. I think also as a test case, I mean, the fact that the two deaf women wanted an interpreter during labor. I mean, you can't get a situation, like if you don't want to say, a situation where the obstetrician said that communication was essential, and it's very hard pressed to think of alternatives. I think it was a great test case, and probably why I was so shocked when I read the decisions in the lower courts in British Columbia. But I do think by paying attention to the dynamics and the way in which the Section 1 machinery gets played, I think that helps in choosing test cases as one example. But I think more generally how to use the law to foster certain public interest causes. I think that maybe that's a larger conversation to have perhaps after the panel.
Okay, so I think that's all for questions. Rachel perhaps is going to come and explain how lunch is going to work, but rescue us from plummeting blood sugar levels. I want you all to join me in thanking our panelists.